Let's start closing arguments at this time.
May I hear Your Honor?
You may, sir.
All right. May it please the court, let's just remember a little bit of the history of this thing. It started out with a physical altercation between Mr. Minton and Mr. Howard back in 1999. That resulted in an injunction. The injunction came up for renewal at the end of 180 days. We tried to renew it in Mr. Howard's name only. The court denied that. We decided we would see if we actually needed one and didn't immediately refile. The next thing we knew, there was another physical altercation between Mr. Minton and somebody. There were pickets in front of the Fort Harrison Hotel. There was a Hindu wedding disrupted. There were police cars all over the place, 6 to 10 police cars tied up, resources, etc. And so that resulted in injunction number 2. The point of that little bit of history, Your Honor, is to simply say that this is an issue of civil order in the city of Clearwater. It is not an issue whether the plaintiff or the defendants are good or evil. The defendants have sought to paint the plaintiff as an evil empire. We're way past that issue. The question is civil order in the city of Clearwater. The simple issues are, what does the law provide? What does the injunction say? What was the defendant's conduct? The greater issue is, in this matter, are the police, the parties, the court going to have to continue devoting inordinate amounts of time to this matter, or is the court going to signal defendants that the court's order has some meaning? Is it going to be the rule of the law or the rule of the mob? Now let me just get down to Ms. Bazazian. Compare this statement she made on the stand. Quote, I was in full agreement with the judge and the injunction. With her statement on December the 6th, 2000 on the internet posting, paragraph 8, here's what she said. Having the cult go through all this effort to get bunches of people, myself included, in this bogus injunction, knowing they were hoping it would stop us as it gave limitations to where we could pick it, the truth is we loved it. It protects us more, which is extremely important, as they were getting quite violent, beating up BM a few months ago. It didn't work at all, Ray stopping us. We were everywhere, and that was great to see. Also, compare the reference here to the bogus injunction and to her megaphone yelling that it was a stupid injunction. I think this reflects her true attitude toward this injunction.
You cannot come within 10 feet of us for your own stupid injunction that OSA has wasted their time on. It now gives us protection to be here once again. OSA, you've created your own enemies. Wake up, Antonio.
Now compare her conduct to what the injunction says. Officer Butterfield explained it to her 5 times. We now know that the police lieutenant also explained it to her, and she was in next to Mr. Henson on that videotape, listening to that. He specifically told her, if you don't want to pick it, this is real simple. If you don't want to pick it, hold it upside down. That was the rule of the game. If they didn't want to be considered picketing, hold it upside down, you go anywhere you want. It's real easy. And they wouldn't do it. They were defiant about it. They wanted to hold that picket sign up no matter what. She picketed alongside the Bank of Clearwater building, came down there with the 2 pickets up after she had been told by Officer Butterfield, and she was told by the lieutenant, and she was told by the female officer, whose name I can't pronounce at the moment. And then she blocked the entranceway to the Cushman building, knowing full well that the order says stay 10 feet back. She blocked it. She was bent over. There was a car stop there. The video shows that there was a van out in Fort Harrison. So she violated it, clear cut, right where she was not supposed to be, and she did it anyway. And, Your Honor, doing it after warning, after explanation by the 3 different police officers, can only amount to a willful violation. Her pre-hearing words and conduct reveal an utter disdain for the court and its injunction, referring to the injunction variously as stupid and bogus. Now the camera tampering. The court, the various provisions of the injunction are that the parties are enjoined from committing any acts of harassment against any member of the church, also ordered to picket, protest, and or exercise First Amendment rights only in the areas designated in orange, enjoined from coming within 10 feet of any member of the church, blocking the path of any member of the church from physically or by any other means inhibiting any church member, any member of the general public, or any motor vehicle from entering or leaving any properties owned and or operated by the church. The conduct of Messrs. Merritt and Minton constituted at least harassment. It constituted a protest outside the permitted orange zone. It inhibited church members from entering or leaving the Bank of Clearwater building. They were doing it right next to an entranceway there. And they had really absolutely no right to engage under these circumstances in self-help with respect to their protest to this camera, about which they were apparently unhappy, and about which they all poured out of the building to examine and inspect. If they wanted to inspect it, they should have filed a motion in this court and not resorted to that. With regard to the obstruction of service or process, Your Honor, the tape, the video on this tells it all.
Listen, you come within 10 feet of me and you guys are going to get killed. Get the fuck out of here. You better get your ass out of here, lady.
It has been
served. Get your ass out of here.
It's a contempt of court to obstruct the process server. It's also a crime. It's also the state of Florida has decided it's serious enough so that it can be a third-degree felony if violence is involved. It violates his conduct violated that part of the rule saying that the 10-foot rule doesn't apply to process servers. You had ruled that 5 weeks over. This doesn't apply to process servers, and yet he was making a big scene that it does. It also can take if there's a clear death threat, although she was supposed to understand it meant you were going to kill her instead of he. It was an act calculated to obstruct the court and the administration of justice, and Mr. Minton was served with papers that we had to serve him with, including an order to show cause. He was served with an amended and supplemental complaint that they insisted he be served with, and that service on counsel didn't count. That's why he got served. They made that insistence on the 20th of December 2000. We made the service on January the 5th. Case of Giles versus Renew, 639 Southern 2nd 701, clearly holds that orders to show cause must be served by a process server. Order to show cause would not have been valid against Mr. Minton had we not served him on January the 5th. Now, let's see, Minton, Anderson, Lerma, and Gagola, that's JOB, is that correct, Your Honor?
I'm sorry?
The Minton, Anderson, Lerma, and Gagola along the side of the Coachman building, was that a JOB?
That was a JOB.
Okay, granted.
Yes, sir.
Okay.
The last one is the Minton three-peak
okay, all right.
On the west side of Watterson in a restricted zone.
All right. Your Honor, with the picket pole in hand, which I don't see how a reasonable person can believe that pole is anything but a jab at the court at the authority of the court. That's for you to decide. But whatever, he is going down Watterson Avenue with this pole in hand and with several other of his people in tow with megaphones, and they're hollering and they're protesting, and they get halfway down just past the stripes, and he decides to cross the street and protest by dangling it in front of the windows along the Bank of Clearwater building while continuing to yell. Now I'll leave it up to you. He said he wasn't yelling, but it sounded like his voice to me. It's a kind of a booming voice. It's the boomiest of all the voices of the witnesses we've heard here. So that was an improper protest in a non-orange zone. And Your Honor, just let me summarize what has been going on here. Essentially, we've had a massive amount of game playing. Let's push it to the limit. Let's just see how far we can go. Let's not just abide by this judge's order. Let's see if we can just push and push and push and taunt. And we had the total twisting of the meaning of the 10-foot rule, claiming its benefits but refusing to recognize the responsibilities of the injunction, mocking the court with the picket pole, obstructing process, harassing with yelling through megaphones and other noise, blocking and cursing at police, attempting to enforce the injunction, preserving public order, picketing and protesting in unauthorized areas, inhibiting ingress and egress to Scientology properties, and generally treating the injunction as a joke. As Ms. Bazazzi put it in her internet posting, playing with everyone here, laughing and having a good time. So, Your Honor, the message needs to go out, and the court has sat here with more patience, frankly, than I thought you'd ever have, and listened to all this. And it's time that a message be sent out that we're going to live in this community together. They got a right to protest. We got a right to exist. This sets down the recipe. I look forward to refining it in the future. It's going to be a lot easier to refine if they know you mean business. I think I've said enough, Your Honor.
All right, thank you, sir.